Okay, sorry.
Yeah,
Okay, I'm sorry. And that he wants to make money off of his property. I guess he doesn't live there anymore, but not in holiday subdivision, unfortunately. And I would ask the court grant an order that would restrict the use of short-term rentals in the subdivision.
Okay. All right, Mr. Zhu, you didn't file a written response, but I did review your answer that had some opinions and things to say about that.
And here we go, the homeowner finally gets the floor. Notice the strategy here. Instead of arguing law first, he's arguing fairness. High mortgage rates, rising taxes, expensive repairs. He's trying to paint the Airbnb not as greed, but survival, and honestly. That's where these cases get messy, because emotionally, a lot of viewers are probably thinking, wait, if it's his house, why can't he use it how he wants? But in court, emotion only gets you so far, contracts and covenants. Those are the real heavyweights.
Any argument you want to make to me against the motion? Go ahead.
Yes, Your Honor. I'll say I have counter arguments about Mr. Dan Essett's argument about deed restriction. Basically, by talking to my neighbors and also the vice president, Mr. Tim Reed of our association, there's no such a thing called deed restriction for this subdivision. Before I said, basically, initially about this property for personal use, but because of the high cost of the high interest, and then without Airbnb, I would have sold the house a year ago, right after I bought it, because it's too expensive. And before I set up this Airbnb business, basically my intention is to offset my substantial cost because of the initial removal of the trees, because of the repair cost, and also because of the mortgage, and also because of the increased property tax, and so on. So basically, I called the local zoning office, and also I called title office of Chicago, whether this is allowed or not. And also I talked to my neighborhood, and also reached out to Run Ford. And basically, he stopped by my house. He didn't say no to my setup. And I didn't set up my Airbnb right after I bought it, because that's not my intention. I bought my house on December 20th, 2024. I bought it that time. And quickly I realized this property is so costly, so expensive. And then based on the advice from my friends, my wife's friend, I tried this venture. Basically, because I teach at the university, and my summer is free, I really needed to find things to do. And then initially I thought of doing this type of thing in China, but there the land is owned by the government. You can't do it over there. And here it's possible. And before the setup, I really consolidated all the local officers. The officer answered me directly, correctly, and there was no restriction for setting up.
Yes. So, and Mr. Zhu, Mr. Losnick doesn't dispute that there's no zoning violation.
Okay.
So there's no issue with your use of the property and the government. And your decision to use that property for sounds like a very reasonable approach that you've been taking. But the legal question is that you bought a lot in a subdivision that does have some protective covenants recorded in the Register of Deeds office.
I read it.
And those do include a description that no lot shall be used except for residential purposes. So that covers up, that trumps the zoning requirements. Zoning could say you could put a gas station there, for example, and you wouldn't be able to because of this restrictive covenant.
Oh, this is the turning point right here. The judge just dropped the legal nuke. Zoning laws and restrictive covenants are not the same thing. Translation? Just because the city says something is allowed doesn't mean the neighborhood agreement allows it. Think of zoning as the government's rules. And covenants as the HOA's private rulebook. And when you buy property inside one of these communities, you're basically signing on to that rulebook whether you read every page or not.
So I guess my job today is to decide, is using your property for short-term rentals consistent with or inconsistent with that restriction, no lot shall be used except for residential purposes?
Let me be clear on this. I read this again and again upon receiving this document covenant. I would say any person with standard English levels should be able to read this clearly. This definition is about land use and the lot use. It's not about the house use. So basically the title here is defined as land use and lot use. It's not defined as house use, property use. This is clear, absolutely clear. And we can dispute, I can dispute this with Dan, no problem. And if we have to look at the subtitle, the rest, basically I can read it. No lot shall be used except for residential purposes. That's about the building. It's not about the commercial, any activities in the house. We can imagine, I can teach in there, do summer teaching in my house, and to earn money, that's commercial. And I can also tell people that I need to make crafts or paintings in my house. That's also commercial. This type of activity is not prohibited, it's not restricted, because this restriction is about the initial land use and also initial lot use. And once the house is built, it's built. This house is still a residential house. I'm not changing it. It's still a residential house. Basically, I still own there. I still live there. I come here at least so often, like once a month or even more frequently than that. So basically, it's still my property. I only use Airbnb to subsidize my cost, because without that, I have really to sell the house right away. I don't think I'm changing the nature of the house itself. It's still a residential house. When I'll sell it as residential house. It's not a commercial house. It's not a restaurant. It's not an office. I'm not converting into an office. I'm not converting into a hotel. If I do anything like that, that's against this covenant, but I'm not doing that. And also there's no explicit language here prohibiting the use of the house for commercial related activities. There's no such language. So any restriction on the property use of the house is the violation of their property rights. Because Mr. Ranford didn't pay a penny for my house. He filed this lawsuit against me on his personal belief. It's his personal interest. It's not the interest of the association. At the end, I would say this lawsuit needs to be dismissed because he filed this lawsuit secretively without informing the vice president, Mr. Tim Ray. Tim Ray didn't know this lawsuit. And also there was no consensus coming from the association. This association doesn't have the rights to enforce any non-existing house rules. There's no such a rule prohibiting what. And also this covenant can be read again and again by myself. So it's about the initial setup of the house. It's not about the restriction of the use of the house. And also I'm not changing the house.
I'll give Mr. Zhu this. He's making a surprisingly sophisticated argument for someone representing himself. He's basically saying, I'm not changing the residential nature of the house. People are still sleeping there, living there, existing there. That's actually a real legal debate courts across the country have wrestled with for years. Is an Airbnb still residential use? Or does constant short-term turn overturn it into a business operation? This case is sitting right on that fault line.
to a different type. It's still residential house.
Okay, thank you, sir. Mr. Losnick, any rebuttal argument?
Just quickly, Your Honor, it says residential purposes, not just, so if the purpose on the property, which the house is permanently attached to the property, is commercial, then it's in violation of this restriction. There's no case law that I know of that provides basis for his argument.
That's your extension, your explanation.
Hang on,
That's his explanation.
Mr. Zhu. How court cases work then is the person that filed the motion argues first, and then you get a response, and then they get a brief rebuttal because they carry the burden of proof. But it's not an open forum for crosstalk and debating. Go ahead, Mr. Losnick.
Okay, so there's no case law that supports this position. Is for residential purposes. To say that you can use the house but not the land is silly because the house is permanently attached to the property. And when you do a deed, you pass that on. You pass anything that's permanently attached to it. So that interpretation of the residential covenants that restricts it to residential purpose, I don't think is a valid argument. And the fact that Mr. Reed didn't know about this lawsuit beforehand is, a lot of people didn't know about it beforehand. So I don't see how that's significant towards this issue. That's all I have.
Okay, thank you. Well, the plaintiff has filed a motion for summary disposition under 2.116C10. And I do believe there's no genuine issue of material fact here. The parties seem to agree on sort of what the facts are, that that there is a land use or a protective covenant that says land use and building type, no lot shall be used except for residential purposes. And that the defendant has been using his lot for purposes of short-term rentals through Airbnb. And he candidly describes that he does that because of the monetary benefit that he receives. Defendant first asserts that the plaintiff can't bring this lawsuit because somehow the plaintiff's president is acting improperly under the bylaws of the plaintiff association. And he's alluded to that today, and in his written answer, he goes into more detail about that. I don't see that as a matter that's for the court today in this litigation. This litigation is not about the internal workings of the association. The association, which would have standing to bring the lawsuit, has brought a lawsuit. Whether the association wishes to withdraw that lawsuit would be its own business. It wouldn't be this court's business. So I don't think this court can penetrate into an organization that has brought a case for me to start asking whether the organization followed its own bylaws about whether all the members approved the litigation or not. That's a matter for the property association to sort out. But they do have standing to bring the action. The restrictive covenants or deed restrictions, here they're called protective covenants, they are enforceable as a matter of contract law, but because they also limit the free use of land, they are strictly interpreted against the person seeking to enforce them, and courts may not read them too broadly, and all doubts are resolved in favor of the free use of property.
And now the judge enters full law professor mode. Watch this carefully because this is how judges actually make decisions. He's not just giving opinions, he's walking through precedent. That's the backbone of the American legal system. Trial judges usually don't get too freestyle. If a higher court already answered the question, lower courts are expected to follow it, even if they personally disagree.
So if I were starting this on a blank slate and asked the question, are short-term Airbnb rentals consistent with residential use? I think that's a fascinating question. And I think there could be good arguments to be made on both sides of that question. But I don't get to decide that issue on my own. I have to follow binding case law on that. And there are a number of cases over the years that have interpreted residential use restrictions. You know, Connor v. Resort Custom Builders, 459 Mich. 335 in 1999. The Michigan Supreme Court held that timeshare ownership or interval ownership violated a restriction limiting use to residential purposes. Now, although short-term rentals are not quite the same thing as timeshare ownership, the reasoning of O'Connor is important. In that case, the Supreme Court noted that to be a residence, it has to have some measure of permanence, such as someone keeping their belongings there while they are absent. Because a weekly timeshare was too temporary to be a residential use, and the people using it do not have any right to be present or store items beyond their 1 week of timeshare ownership, the Supreme Court held that that timeshare did violate the restrictive covenant. And from that reasoning, short-term rentals, such as through an Airbnb, would also tend to not be a residential use. In fact, an Airbnb guest would typically have less interest or concern for the premises than would a timeshare owner. But it wasn't a short-term rental case. Then we have Eager v. Peasley in 2017, Court of Appeals, 322 Mishap 174. And it held that short-term rentals violated a use restriction requiring, quote, private occupancy only, unquote, and prohibiting, quote, commercial use. But Eager isn't directly on point, though, because as recognized by the Supreme Court in Terrian v. Swit in 2002, a covenant barring any commercial or business enterprise is broader in scope than a covenant permitting only residential uses. So here, the covenant at issue does not prohibit commercial use expressly. So the fact that the defendant receives money for the short-term rentals is not itself dispositive. But the covenant here restricts to residential purposes. So the question, unanswered totally by O'Connor and Eager, is whether short-term rentals violate that type of residential use restriction. Well, there was a case in 2023 where the Michigan Court of Appeals did answer that question. In the case of Aldrich v. Sugar Springs Property Association. In that case, the restrictive covenant said, quote, all lots in the development shall be used for residential purposes only. Thus, the restriction in Aldrich was essentially the same as the one at issue in our case. And in Aldrich, the Court of Appeals held that short-term rentals of any term less than 6 months did violate that use restriction. And the Court of Appeals explicitly rejected the homeowner's attempt to distinguish the O'Connor and Eager cases, holding instead that the legal reasoning of those cases meant that short-term rentals are not allowed where there's a valid restriction to residential purposes. Aldrich is quite clearly on point, and it is binding on this court. So this court, Mr. Zhu, really has no discretion or decision to make.
That line right there, this court has no discretion. That's devastating for the defense, because once the judge says binding precedent controls the outcome, the hearing is basically over. Mr. Zhu wasn't really fighting this judge anymore. He was fighting previous appellate court decisions that had already defined short-term rentals as violating residential. Use only covenants in Michigan. At that point, the judge's hands are tied.
I am bound by oath and law to follow binding precedent of the courts above me. And Aldrich dictates the result that the Plaintiff Association is entitled to judgment as a matter of law. And this would include the count, Mr. Losnick, for declaratory relief, as well as the count for injunctive relief, because it's long been the case that restrictive covenants may be enforced by injunction, there being generally no adequate remedy at law. So therefore, the plaintiff's motion for summary disposition under C10 is granted as to declaratory and injunctive relief. And Mr. Losnick, you may submit a judgment under the 7-day notice of presentment.
Thank you.
All right, thank you. So you may not do the short-term rental.
And what's the consequence? What's the time frame? How long?
So the process, Mr. Losnick will have to prepare a proposed judgment. He sends a copy to you and to the court. You have 7 days to object to the form of the judgment, and that is only if his judgment does not fairly capture what my ruling was. It's not a way for you to object to what the ruling was. And then we get a written judgment entered. And then there's a period of time that you can file an appeal to the Michigan Court of Appeals. If you wish to do so, you may certainly do so, to have them review my decision to see if it's legally correct. Okay.
So that means my Airbnb can still go as it is until the appeal court decision is made.
Well, those are questions that I can't really answer today. Those would be questions about a stay. What I'll tell you today is I am ruling as a matter of law that the Airbnbs are not, that they do violate the restrictions. As of right this moment in time, there is no written piece of paper court injunction against you for that.
Okay.
Once that paper does issue, then that would be binding. There are some court rules about when that injunction takes effect and what you would have to do to seek a stay of the injunction. So I'd refer you to the Michigan court rules, or you can consult with an attorney if you wish. There's also the law library has a legal help center. You can review it down there. So there are some wrinkles to that, but generally, once that injunction is signed, you're going to have to follow it.
Notice how calm Mr. Zhu stays after losing. No yelling, no meltdown. He immediately pivots to procedure. Appeal rights, injunction timing, enforcement. That's actually smart. A lot of people think courtroom drama ends with the ruling, but legally, this is often just the beginning. Appeals, stays, enforcement, orders. Civil litigation can turn into a marathon real fast.
Okay, anyway, I will appeal this decision.
Yeah, you certainly can do so.
And I'm not, basically, I'm not liable for any court fees whatsoever, right?
Yeah, in the American system, both sides pay their own way. Yeah,
okay,
with some rare exceptions, and Mr. Losnick has not asked me to trigger those exceptions.
Sounds good.
Okay.
Yeah.
All right.
Thank you.
You have a good day, sir.
Thank you.
Thank you, Mr. Losnick. All right, and up next, Mr. MacArthur, we'll call your matter. I'll bring in the parties here. All right, and up next we have...
And just like that, courtroom whiplash. We go from a major property rights showdown straight into scheduling conferences and procedural housekeeping. Welcome to real court life. 1 minute it's precedent-setting Airbnb debates. The next it's attorneys calmly negotiating deadlines like they're scheduling dentist appointments. TV legal dramas never show this part. But honestly, this is where most civil cases actually live.
The matter of Snook v. Barney. It's filed 25-9176 CK. Let's see, I do see Mr. Peck has zoomed in. There we go. I think I see Mr. Peck. There we go. All right, so counsel, you want to place your appearances on the record, beginning with Mr. Peck for plaintiff?
Yes, Lyle Peck on behalf of Christopher Snook. Thank you, Your Honor.
Tim MacArthur, Your Honor, on behalf of Mary Barney, and I believe that's Ms. Barney on Zoom.
Yes, okay. And I do see there's a Chris Snook that's in the Zoom as well. This is a pretrial for the court to enter a scheduling order. Are the pleadings satisfactory, or are you seeking any amendment of your complaint, Mr. Peck?
I believe they're satisfactory with the pleadings. I'm going to have to take one more look at it. I'd like to discuss some resolutions with my counsel.
Okay. Any objection to my indicating in the scheduling order that amendments may be filed within 30 days with no need for leave of the court?
No, that's fine, Your Honor.
Okay.
I might have an amendment to our answer also.
Okay, so I'll allow amendments within 30 days without seeking leave of the court.
Thank you.
The initial disclosure, yes, you're welcome. Is the initial disclosures been served by both parties?
They have not, Your Honor. They are pending at this point.
Okay. And I'll give you, I guess, 28 days to file the initial disclosures. Mr. Peck, how long do you think you need for discovery? If you don't, I mean, if you and Mr. MacArthur sort it out, that's of course, going to be best for all of your clients. But absent that, how long are you seeking for a discovery period?
I think I'd like to resolve it, but I think 4 months, we should be able to resolve this case or try it.
I concur 120 days would be appropriate, Your Honor.
Okay, we'll do witness list within 60 then. And it sounds, I mean, Mr. Peck and Mr. MacArthur are both experienced attorneys in this area. So unless you want me to, I won't schedule this for any court-ordered formal alternate dispute resolution. Just let you guys sort it out. Does that sound fine, Mr. MacArthur?
That sounds fine.
Fine to you, Mr. Peck?
Yes, I think so too.
Okay. So has there been a jury demand filed, Mr. Peck, or is this a bench trial matter? Looks like
It's a total equity case, so it's a bench trial matter.
What's the estimated length of the trial if it went that way?
I'm guessing about 6 hours of testimony.
Okay, you think 1 day?
1 day, Your Honor,
Okay.
yes.
So at the conclusion of the discovery period, if you haven't resolved the matter, keeping in mind that I would be the trier of fact, do the parties want a settlement conference in chambers with me or a final pretrial on the record? Any preference, Mr. Peck?
I think in chambers with you would be nice.
Mr. MacArthur, any objection?
Your Honor, I've been in your chambers and I'd be fine going back in there.
Oh. All right, so we'll schedule a settlement conference. Let's see, 4 months from now is mid-September. So let's put it on for the October settlement conference date. That'll be October 21st we'll do at 11 a.m. And, I guess I'll also indicate if you guys are close to something and you need a little bit of judicial input, just reach out to the assignment clerk and see if we could schedule a phone conference. I'm always amenable to that as well. But otherwise, absent that or some motion from either side, I'll next see you both in chambers for a settlement conference, October 21st at 11 a.m. Anything further from the plaintiff, Mr. Peck?
No, and thank you, Your Honor.
Anything further from the defense, Mr. MacArthur?
Nothing, Your Honor. Thank you.
Okay, you guys have a great day.
Thank you.
You too.
All right, and then we're going to move into the family division. So I'll end the live stream.